On February 20th, the United States Supreme Court handed down what many are calling the most consequential ruling of Donald Trump's second term. And it has nothing to do with immigration or executive power over agencies. In a 6-3 decision written by Chief Justice John Roberts, the court ruled that Trump's sweeping Liberation Day tariffs, duties that reached as high as 50% on countries like India and Brazil and 145% on China, those were flatly illegal. The court noted that the word tariff does not appear anywhere in the 1977 emergency law that President Trump invoked to impose them. The immediate financial stakes are staggering. The government had already collected an estimated $160 billion in tariff payments. Now, the question of whether the money gets refunded is headed back to the courts. But meanwhile, within hours of the ruling, Trump signed a new executive order imposing a 10% global tariff and by Saturday raised it to 15%. This time, he cited a different legal authority, Section 122 of the Trade Act. Global markets lurched. Trading partners from Canada to the EU scrambled to reassess ongoing negotiations. And for a country like India, just short of a delicate bilateral trade agreement, the ground shifted overnight. So, what does this mean legally, economically, and for India specifically? Listen on. It's Tuesday, the 24th of Feb. I'm Anirban Chowdhury. This is the Morning Brief. To understand this better, I spoke to Bipin Sapra, tax partner and global trade expert at EY India. Hi Bipin, very warm welcome to the Morning Brief.
Hi Anirban, thank you for having me here again.
Pleasure. Okay, basic question to you. How do you read this latest development?
The US Supreme Court has delivered a landmark judgment. That's the least one can say. And the reciprocal tariffs, which were introduced under the International Emergency Economic Powers Act, or the IEEPA, under which these tariffs were imposed, the Supreme Court has struck it down. Now, what it means is that at least under that section, tariffs cannot be imposed for the reasons which were given earlier. However, the president has gone ahead and introduced tariffs under Section 122 of the Trade Act. Now, there are different conditions under which the tariff, which is right now being imposed at 10% and has been proposed to be taken to 15%. What it means is that the president's intent to impose a tariff of 15% is quite strong, and he continues to believe that that is how the future regimes or the future economy should look like. Now, this flip-flop means that the whole scenario continues to be very uncertain. From an external perspective, one sees that for goods being imported into US now are under debate once again. From an Indian perspective, that debate is whether it was 50% some time back, it got reduced to 25. The negotiations which were going to bring it down to 18 are still on. The final executive order was to be signed. Now the tariffs going down to either the 10% or the 15% brings in a huge amount of uncertainty.
Understood. Now, broadly speaking, it's a play between the IEEPA, the Section 232 and Section 301. For a broader audience, can you explain the difference between the three and why taken together they have given the US president multiple pathways to still impose tariffs despite a court decision?
Yeah, keeping this to a basic level, IEEPA allows the president broad authority to regulate economic transactions in the event of a national emergency. It allows the government to deal with any unusual or extraordinary threat to national security, foreign policy, or economy of the US when the source of such threat is wholly or substantially outside the US. IEEPA gives the powers to the president to investigate, regulate, and prohibit transactions in foreign exchange, transfer of credit payments, import and export of currency and securities, but not necessarily tariffs, it would so seem. Without going into the debate whether IEEPA is applicable or not, that is the broad context in which IEEPA operates.
Got it.
Section 232 of the Trade Expansion Act of 1962 authorizes the president to impose tariffs or quotas if the Commerce Department determines that the imports threaten to impair national security by undermining domestic industries critical to defense and supply chains.
Okay.
Now, the purpose is basically to evaluate whether these imports threaten the defense and the economy, and there can be various measures for that, which have been laid down. But it's a long drawn process, Anirban, where starting from an investigation triggered by an executive agency or the Department of Commerce or any interested person to a notification to the Secretary of Defense. It can also be an investigation conducted by the Bureau of Industrial Securities. And the president's ultimate decision and notification to the Congress would be the culmination of this process. It can even take an year to actually execute the whole process. Section 301 of the Trade Act of 1974, that grants the United States Trade Representative, what we know as USTR, to take action such as import restrictions, tariff, etc., if the rights of US under any trade agreement are denied or any act, policy, or practice of a foreign government is burdening or restricting the US commerce. It's again a long drawn process and an investigation is required. But that's what Section 301 does broadly.
But does this tell us that the court ruling was largely inconsequential? And what precedent does it really set?
In my mind, the Supreme Court ruling was not inconsequential. It was setting a precedence from a perspective of that IEEPA and the emergency powers therein cannot be used by the president to impose tariffs. That per se is now a settled issue. If there are powers within other sections, then the president will have to look at those powers to really see if tariffs can be imposed. But can he impose without the sanction of Congress is the question which is getting answered. And the first step is that IEEPA cannot be the choice for imposing these tariffs. And that, I think, is not inconsequential.
Really important question. How do you think this will impact the Indo-US trade deal?
The Indo-US agreement or the proposed agreement had brought in hope that this will get to an 18%. And there were relative taxes which would give the Indian exporters either relative benefits or they were still at a loss in cases of certain things. But prominently, that was bringing in certainty for the exporters to calibrate and move forward in terms of their future sales and their future exports to US. Now, this changes because this will now mean that everybody is going into a wait and watch mode to see where these tariffs end. We also need to look at whether the earlier agreement which India and US were signing, does it still stand good or would that also change as we move forward?
Right. But the larger question is, can or will India walk away from the deal? Will the conversation at least take a fresh turn?
I think, except the percentage of 18% which was being finalized, that now comes under the dispute.
Right.
If that 18% doesn't exist, if it cannot be imposed, can 232 be the law for choice or the rule for choice for the president to impose a 15% tariff? And that too, it can only be done for a limited time. These are not unlimited powers. So signing an agreement for India needs to be carefully evaluated depending upon where the tariffs can actually stand.
Understood. Now, what are the tax implications of this? I mean, are there any, especially on India's effective corporate tax on US bound goods?
See, any tariff which is being imposed that has an implication from a corporate income tax, from a transfer pricing perspective, all of those things there will be an impact for the industries. The reason being, depending upon how the contracts work, how the market operates, the tariffs which are being imposed in US will either be absorbed buyer there, or it will be shared between the seller and buyer, or it will be totally passed on to the seller, depending upon the product, depending upon who has the advantage out there, and other market phenomena. In all of these cases, if the profit margins or if the margins under which the Indian company operates, they are getting hit, then the corporate income tax would definitely get impacted in those cases.
How will it affect transfer pricing risk assessments? especially for Indian multinational companies selling into the US market?
It's the same question, Anirban, as to how much the profits which were being booked in US or the margins which were there, how does that get impacted by the companies who are exporting goods from here to US? And
Right,
it's only the goods companies which are getting impacted by this.
right.
But there'll definitely be a change in terms of the transfer pricing which is being maintained, because some amount of tariff cost which is going to become is going to be shared between the Indian company and the US company. And that will impact the transfer pricing and the risk perspective among the two companies.
Got it. And that's also the impact that means that this will have on decisions by US MNCs in India, right?
All of these are getting impacted, and they'll accordingly also move forward depending upon how the supply chain is working and how it is getting impacted.
Okay, Bipin, last question. How do you see the next 2-3 months panning out, or rather the next 2-3 weeks? And what are the 2-3 questions that have to be answered so that experts like you have some kind of certainty about what's really happening?
Yeah, it's a interesting time. It's a time where for the Indian exporter, there is uncertainty. For the Indian government who's out there negotiating an India-US trade agreement, there is lack of clarity in terms of what is the final rate at which these tariffs can be imposed, are being imposed, or will stick, because that would be the point at which the discussions would begin. However, once the agreement happens, at whatever rate, then there is no question as to what rate would apply. So if India signs today, say at 18%, but tomorrow the tariffs which can normally be imposed on other countries either remain at 10% or are not there, then India will be at a disadvantage. So it's a question of understanding how the scenario will pan out. For Indian exporters also, it's a time to wait, watch and see where the final rates would stop. And hence, while strategies are a must and the strategies need to be continually evaluated by the exporters, to really execute these strategies, I would want to wait for 2 or 3 weeks to really see how the phenomena unfolds and the tariffs and the sections under which these tariffs can be imposed really become more certain.
Understood. Bipin, thank you so much for joining us.
Thank you, Anirban. It was a pleasure once again.
The Supreme Court may have shut one door, but the White House has wasted no time looking for others. What's clear is that the era of tariff uncertainty is far from over. It's simply entered a new, murkier phase. We'll be tracking this story closely. Until next time, thank you for listening to The Morning Brief. This episode was produced by me, sound designed by Indranil Bhattacharjee. The Morning Brief drops every Tuesday, Thursday and Friday on a listening platform of your choice. Also listen to Corner Office Conversations, where we talk to the most interesting business and thought leaders from India and the world on Mondays, wherever you get your podcasts. Stay tuned.